hidden defects, in such case, obviously, accepting the works will not have legal consequences in terms of loss of guarantee for the obvious reason that the defect is not visible. So the guarantee will cover you up to the moment when you actually find out the presence of this defect in construction. Okay? In that moment, you have to once again go ahead and take the same remedy that I just explained 1 minute ago. Talk to your lawyer, get your lawyer to write a letter of default requesting the contractor to take full responsibility for this. From that moment, you will have 2 years eventually to take legal action and take your contractor to court, should that be necessary. But in most cases, a letter of default is enough in order to make sure that the contractor takes full responsibility for this problem. There is one third case when not only the defect is hidden, but furthermore the contractor is having a behavior showing which is defined as malicious, is acting in bad faith, is proactively hiding this defect. Okay? Obviously, legislation protects the consumer in such sense and provides for 5 years guarantee in these cases, meaning you would have not only a hidden defect, but also you have to take in consideration the behavior of the contractor. You need a behavior which is somehow malicious, aimed to hide, to reassure you, and hide the entity of the problem. What is interesting, should you highlight, should anything wrong like this appear, once you sent out a letter of default, what is useful and what is protective is the fact that it's no longer your responsibility having to prove the negligence of the contractor. I mean, it's exactly the other way around. It's the contractor who will have to prove his diligence. Okay, and obviously this will put you in a strong position, I would say. Under these circumstances, I mean, what are the remedies? What are the options provided by the Italian law? I mean, obviously you can ask for the elimination of the defects or the unauthorized variations. I mean, I have some clients, for example, they requested a property having a patio, and the builder did not build together providing a patio. This is typically a case of unauthorized variation for which he has to take, obviously, full responsibility. So, option 1, requesting the elimination of the defect and the variation and at full cost of the contractor. You can ask a reduction of price. If the variations are very serious, you can request the rescission of the entire contract and also requesting a compensation for damage. There is, according to Italian law, a specific legislation concerning new builds. Such legislation seems to be quite restrictive. In fact, it only concerns serious defects in construction, total or partial collapse, risk of total and partial collapse. So we might believe, I mean, it's extreme cases, but as a result of the jurisprudence, is defined as serious defect in construction any defect referring to works which are by nature aimed to last for a long time. An example, your roof was supposed to be waterproof. You signed the contract 2 years before, it's raining inside your property. I'm sure many of you experienced this. It's a very recurrent case. Such kind of works will be under guarantee for 10 years. Let me give you some examples resulting from jurisprudence of serious defects. It could be defined as serious defect, any defect that ends up jeopardizing the use of the property, or that might have a significant impact on essential structural elements such as solidity, efficiency, and duration of work. Examples: detachment and rupture of a significant number of tiles, inadequacy of thermal insulation, defective heating system jeopardizing the normal use of the property, defects concerning the roof of the property causing infiltration of water, inefficiency of the plumbing system, defects of the chimney jeopardizing the normal use of the property. One final aspect that is extremely significant, is extremely relevant, is the inspection. When the works are actually terminated, before you actually accept it, it's very wise involving your legal advisor and involving a surveyor in one inspection of such works. This will ultimately give you a clear understanding of the quality of the execution of works. Bear in mind that such right does not arise only at the moment of termination of works, but you can actually request for inspections. It is actually useful to do so while the works are undergoing. So if there is something wrong, I mean, you are in a position to fix it at the very beginning rather than at the very end. Because at some stage, if you decide to accept such works without any letter of the default, without challenging them, ultimately, you will end up, being in the position to be responsible for payment, and this obviously is something you would like to avoid should any significant problem arise. So if you omit, if you forget to raise any legally relevant objection and you accept works, you will not have remedies any longer, at least for visible defects. For hidden defects, as we explained before, you will have the possibility to take action in the moment when you actually find out.